One of the areas of law that I'm most passionate about are the bounty and awards provisions under various, oftentimes federal statutes, but a few state statutes as well. One of the main whistleblower bounty statutes that we work with is the False Claims Act, in particular the Federal False Claims Act. Many states have their own state versions of the False Claims Act, but the federal one is one of the broadest umbrellas and protects and covers the most actions. The False Claims Act has a really interesting backstory, actually. During the Civil War, there was a lot of merchants who were selling goods to the Union Army. And in many cases, those goods were not what they were supposed to be. So things like kegs of gunpowder that were a quarter gunpowder on top and 3/4 of sawdust underneath. Donkeys who were supposed to be horses. And so really what was occurring is the government was paying all these funds for goods and services, but they weren't actually receiving what they were paying for. They were receiving less, or they were receiving worthless goods. And so following what British law had done in a couple of different instances previously, what then President Abraham Lincoln and the Congress that was in place at that time did is they enacted a law that essentially encouraged people to come forward and to report this kind of fraud on the government. And the way they did that is they said an individual can essentially stand in the shoes of the government, and they can participate in what's called a Qui Tam action. And Qui Tam's a short truncation of a much longer Latin phrase that I can't pronounce. But essentially what it means is that an individual can stand in the shoes of the king and enforce the king's rights. And so the king in this context was the federal government. And so really what this Qui Tam provision was doing was allowing individuals who had unique knowledge about these fraudsters and the fraud that was being perpetuated to act as the federal government, to enforce the federal government's rights, and to say, I, as a representative of the federal government now, am going to sue you and recover the money that the federal government fraudulently paid out, that the federal government would have not otherwise paid out. And in return, what the statute, what the False Claims Act gave these, what are called relators, these whistleblowers, is a certain percentage of what they were able to recover. In modern times, that percentage usually varies between 15 and 30% of whatever the relator is able to recover. Fast forward a couple of centuries, really, the False Claims Act has become much more powerful. For many years, the False Claims Act kind of languished and wasn't used all that much because it didn't provide the sorts of protections and didn't provide the force that was necessary to allow relators to really participate in these Qui Tam actions. A lot of that changed in 1986 when the statute was substantially revised. And over the years, those 1986 revisions have been even strengthened more. Recent changes under under three particular statutes, under FARA, under the Dodd-Frank Act, and then again under the Affordable Care Act, have all strengthened the Qui Tam aspects of the False Claims Act, as well as the anti-retaliation aspects of the False Claims Act even more. So really what a False Claims Act claim is, speaking from a Qui Tam context, in other words, speaking from the context of an individual who becomes a relator and is suing someone on behalf of the federal government, is about recouping funds that were either fraudulently paid by the federal government or paid because of fraud, or recouping funds that should have been paid to the federal government but weren't because of fraud. There's multiple ways to prove a False Claims Act violation, but the knowing submission of a false claim, or what's called the Reverse False Claims Act, the knowing avoidance of an obligation to pay the federal government, are two of the most common ways that a relator brings one of these types of claims.